Welcome everyone. It is my great pleasure to talk very briefly about fundamental rights and constitutional law aspects of clean energy and AI. I also would like to thank you to Vicente, Marinella, and Robert for including me and to inviting me to this conference. It's my great pleasure. So my presentation addresses how the European Union's constitutional framework is being tested in the dual transformation we are living through, the green energy transition and the digital revolution, especially artificial intelligence. So I will explore how these two forces converge, the emerging legal tensions and possible constitutional responses. So the main question I would like to address is how can EU law balance technological innovation in AI-driven energy systems with fundamental rights protection and national constitutional identity claims. My argument will be that AI in energy will soon become a testing ground for constitutional dialogue, much like data protection and monetary policy were in the past. So the EU is undergoing what I already mentioned, a dual transformation. Decarbonization through the Green Deal and the energy transition, and digitalization through the AI Act, DSA, data governance frameworks. Energy is a strategic sector, AI is a strategic technology. The central question is whether EU law can reconcile these two revolutions without producing constitutional conflicts. Just to mention a few examples, smart meters, they generate minute-by-minute consumption data, which AI can use to optimize grids. Yet, such data may reveal intimate lifestyle patterns and invoke privacy concerns. Another area can be social justice, as also mentioned by speakers the day before. AI-driven dynamic pricing may disadvantage vulnerable households. This directly engages Article 34 of the EU Fundamental Rights Charter and national guarantees of human dignity. The law must prevent exclusion from essential services. We also heard that AI brings clear benefits. It optimizes forecasting for renewable energy, such as wind and solar, balances supply and demand in real time, and even supports long-term grid planning. Smart meters and dynamic pricing can increase transparency and consumer savings while helping regulators enforce environmental law. These benefits explain why the EU sees AI as a strategic technology in energy. There are key legislations, as we all know, the TFEU provisions on the internal market, energy and data protection, the rights in the Fundamental Rights Charter, such as privacy, freedom of expression, economic freedom, and secondary legislation, particularly the AI Act, Renewable Energy Directive, or the Electricity Directive, just to mention a few important ones. Together, these provisions form the battlefield where the new tensions will play out. The AI Act takes a risk-based approach. AI in critical infrastructure, such as electricity grids, is classified as high risks. This means providers must meet stringent requirements on transparency, robustness, and oversight. Deployment of AI in energy touches several charter rights, as already mentioned: privacy, data protection, through smart meters, freedom of information, through explainability of algorithms, economic freedoms for providers, and environmental protection as a guiding principle. These developments cannot be understood without reference to constitutional doctrine. National constitutional courts have insisted on two major reservations: ultra-vires review policing the limits of EU competencies, and constitutional identity-based review. Germany's PSPP judgment illustrate how proportionality and democratic legitimacy concerns can trigger judicial resistance. These doctrines are highly relevant as AI and energy law expand EU competencies. Let me underline, while there is no preliminary reference yet combining energy and AI, there are very important cases, as we heard yesterday from Judge Csehy. For example, the Bulgarian energy holding case, where the court dealt with the intersection of competition law and energy policy. The judgment confirmed that in the energy sector, market integrity and EU competition rules prevail, a principle that will likely extend to AI energy regulation. Equally relevant is the Hungarian case with the Hungarian Energy Authority, which we also heard about yesterday, which turned on the right to effective judicial remedies under the gas market directive. This highlights how once AI takes over decision-making in energy, questions of judicial review will become even more pressing. AI is already being deployed in energy. It's already mentioned in smart grids, where algorithms govern dynamic pricing, in renewable certificate trading, where automated verification could replace human oversight, and in energy security, where AI-driven monitoring tools assess systemic risks. Each of these areas could generate fundamental rights issues, from data protection to economic freedom. These risks are very significant risks. AI systems are opaque and constantly evolving, making accountability harder. Data centers needed for AI consume enormous amounts of energy and water, creating environmental burdens of their own. And in critical infrastructure like electricity grids, AI introduces cybersecurity vulnerabilities. Manipulation or failure could have systemic effects. Finally, algorithmic bias could distort access or pricing, undermining fairness. The fundamental rights-related risks are clear. Article 22 of the GDPR limits automated decision-making, which is directly relevant to AI-managed energy pricing. The AI Act requires transparency and human oversight, but this may conflict with efficiency goals in energy. And let us not forget the social dimension. Algorithmic pricing could exacerbate energy poverty, raising concerns under the Charter's non-discrimination and social rights provisions. AI Act obligations could well conflict with national constitutional protections or data sovereignty, energy sovereignty debates. We also heard about ongoing cases in social rights and energy security, which demonstrates that alongside supply security and environmental goals, social rights and safety concerns are also in play. If AI-based pricing or data processing undermines individual rights, we should expect similar types of conflicts. How might national courts respond? We can expect constitutional identity arguments around democratic legitimacy and proportionality. Sovereignty in choosing the energy mix is central, potentially framed as identity. National courts may resist. Germany's PSPP judgment shows willingness to challenge the CGEU. Yesterday, we also heard about the very recent Poland versus Parliament case, which is emblematic. Here, Warsaw argues against centralization in energy regulation, invoking sovereignty. This foreshadows that if the AI Act or other digital rules interfere too heavily with national energy choices, constitutional identity and ultra-vires arguments could resurface. And finally, if you look ahead, we can expect the first genuine AI energy preliminary references within the next 2 to 3 years. The doctrinal question will be whether national courts invoke ultra-vires reasoning or identity review. Either way, there is a risk of fragmented constitutional oversight unless the CGEU, national courts, and legislators engage in genuine constitutional dialogue. My conclusion is that AI in energy is an emerging litigation frontier. Fundamental rights will serve as the balancing tool. Scholarship by Joseph Weiler on constitutional identity, constitutional tolerance, and by Bruno De Witt on dialogue on judicial dialogue helps us conceptualize how Europe can navigate these conflicts. The EU's AI Act embodies this balancing act by classifying AI in energy infrastructure as high risk. It requires transparency, human oversight, and robust liability rules. But we must also think more broadly. A multidisciplinary approach is needed, aligning AI deployment, not just with efficiency, but with fairness, sustainability, and constitutional rights. And to conclude, AI is key for decarbonization, but legitimacy depends on fundamental rights compliance. Conflicts between the CGEU and national courts are inevitable. Policymakers must anticipate them to avoid a deadlock. In my opinion, the EU stands at a constitutional crossroad. Digitalization and decarbonization are converging, and the energy AI nexus is becoming the ultimate stress test for constitutional law. The key challenge is to foster judicial dialogue and legislative foresight, ensuring that innovation and fundamental rights advance hand in hand. Thank you for your attention.